Justice Epstein, who was a classmate of mine at U of T Law School, so you'll think I'm younger than I am as a result of that, lived on I think I got that right. Lived on an island in Temagami, Ontario, and owned and ran a fishing camp after getting her Bachelor of Commerce. Then she returned to Toronto to go to U of T Law School, where we graduated together. She worked then with Fasken and Calvin and Fraser and Beattie before starting her own law firm of Gloria Epstein and Associates. She became a Queen's Counsel in 1992, I presume federally, and was appointed to the bench in 1993. Now, you've heard a great deal about the Ditchburn decision in the last couple of days, and she was the presiding judge in that decision, as was Justice Gouge of the Court of Appeal. Justice Gouge was a Queen's Counsel in 1982, was managing partner of the firm of Gowling, Strathy, and Henderson, where he had a general litigation practice before being appointed to the court. He was an instructor at the University of Toronto Faculty of Law in Labor Law and Native Rights from 74 to 85. In 1989 was counsel of the Office of the Premier and was active in the CBA's Canadian Civil Liberties Association and the CBAO Ontario. He was a bencher for a number of years and has handled more cases in the last couple of years in the Court of Appeal in the employment law area than any other judge, with a possible exception of Laskin, although it's pretty close. If they would come up, I have a series of questions. Insult.
I was enormously flattered.
Okay.
You went the right way.
Tor, I meant to flatter, not insult. I'm sure. I hope I got that right about the age. Anyway.
You'll find out next time you're in court.
That's right. Now, I have a series of questions, giving you a sneak preview of them, and I'll let you determine whether one of you or both is going to deal with them. And if we could get some water brought to the front by someone in the back, that would be helpful. And I see someone volunteering, so I appreciate that. The first one is probably the one that's most significant to everyone here and for the students in a couple of years. And that is speaking both from the lawyer's perspective and how the lawyer should prepare their litigant's perspective. What makes a plaintiff and defendant's case, respectively, stronger, both in terms of the plaintiff presentation and the counsel presentation? I know that's a simple question, but.
Maybe since I'm the first who sees these guys, I will start. I mean, it's pretty hard to beat good facts and good law. But frequently, that's an area over which you have little control, because by the time you get the case, the facts are set and someone else has told you what the law is, or you should have it figured out. So I'm going to turn to the touchy-feely, what I call the touchy-feely stuff, and I think, quite frankly, that good guys or nice guys finish first. And the Ditchburn case provided Howard with a great segue in the introduction between me and Justice Gouge. But I remember when Mr. Ditchburn was in the courtroom. And I have to tell you something, a confession to make. I have an allergy against people who cluck, roll their eyes, shrug their shoulders, and nod. I also have an allergy against people who overstate and understate their position. Mr. Ditchburn was the perfect plaintiff. He sat in the courtroom for 6 days. He never clucked. He never rolled his eyes. He heard a lot of pretty bad things about him. I mean, the facts and getting drunk on the last day and going to the bar and the strip club and driving the company car and beating up one of the employer's best customers isn't something that normal people like to hear said about themselves. But this guy was a saint in the courtroom. And when he testified, he didn't try to duck any of the bad stuff. He quickly admitted it. He admitted that it was wrong. He had committed a serious error in judgment. Nor did he overstate the good stuff. When he was asked about his employment history, he didn't try to build it bigger than it was. And I responded to Mr. Ditchburn. A few days later, after the case was over, I was at a Blue Jay game, and Justice Katzmann was sitting 2 rows behind me. And I was troubled by the case because I wanted to give Mr. Ditchburn $1 million. And the claim was for $250,000. I mean, I just felt so strongly about this case. So I spoke to Justice Katzmann and I said, he says, you look preoccupied. And I said, well, I'm about to write a decision, and I know that what I'm going to do, and I know it's going to go to the Court of Appeal. And the problem with you guys is you don't have a chance to see these people. You don't have a chance to see what Mr. Ditchburn is really like. And that had a profound influence on me. And Justice Katzmann gave me some very good advice. He said, why don't you describe him in your judgment? That was a good idea. So I did. I don't know whether Justice Gouge picked up on that when he read the judgment, but to make a long answer short, you can't change who your plaintiff is, but you can encourage your witness to behave himself or herself in the courtroom. Some lawyers don't even get it. A lot of lawyers cluck and roll and nod and tick and do all the things they do to try to suggest to the judge that if you don't get it by listening to it, maybe you'll get it by watching my mannerisms, and that'll really drive the point home. And you can also tell your client that he or she may have to say things about themselves that is not flattering. But do it in an honest, sincere, credible way, and you're probably going to impress the trial judge. Not that our decision should be influenced by how much we like the guy, but most of us anyway, are human beings. So we are going to respond to people in different ways.
I agree with everything Gloria said. When I read the reasons for judgment in Ditchburn, I had to use every ounce of self-restraint to avoid awarding him the $1 million. Gloria couldn't. But I think what she says about presenting the case as fairly and reasonably as you can is for me right on target. And early in my practice, I did a fair amount of this stuff, and there is a tension, especially in hard-fought wrongful dismissal cases, because it's so often true that the plaintiff feels desperately aggrieved and the employer feels desperately hard done by. And the lawyer's temptation is to yield to that and to demonstrate just how much on side you are with the client, and so to overstate the case. And I think that doesn't work on either side. I think part of the professional's role is to persuade the client that the most effective way to pitch the case is somewhat less often at a lower octave than the client sometimes wants. And I actually think this is a thing that plagues employment law. There are other kinds of law that are hard fought too, but a wrongful dismissal case often has an overtone of a tinge of personal animosity that I think requires the lawyer's professional judgment to intervene to persuade the client on either side that the way the court comes fastest to the perspective you would like is for you to state the case reasonably and not to overreach. That's just putting another way what Gloria said, and for me that's good advocacy in any case, but it's a particular risk that has to be paid attention to in employment law cases.
So as a practical matter, what you might want to do if you're acting for a plaintiff is read Justice Epstein's decision in Ditchburn and substitute the name of your plaintiff and tell him this is how to behave.
The same applies, I think, if you're representing the defense. It's hard to make a nice, warm, fuzzy employer, but you've got the steel company or the insurance company or the bank sitting on one side of the courtroom, and the secretary of 30 years on the other side of the courtroom. It's hard to come in and present to the trial judge the emotional part of your case. But you can try. You can show that the employer took the matter seriously and hopefully considered both sides of the story and felt bad about the dismissal. And again, avoiding overstating the bad stuff is very important.
To what extent is arbitration law in the last couple of years merging into the common law of employment?
Howard didn't give us the answers to these questions, so I'm not quite sure what the answer to that is. But it is an interesting question to conjure with. Things like in arbitration law, it's commonplace for a remedy to include putting the person back in their job. That has not, and I suspect will not for some time, be a part of what we see in the civil courts, but it's an intriguing thing to speculate about. I was never very sure when I did arbitration law why it was that arbitrators felt they had the jurisdiction to put people back after they'd been fired without cause, and judges never entertained that idea. There are other things that it seems to me are probably areas where the two kinds of law tend to run together. Arbitration law has a long history of procedure being important, so that if you take steps against an individual, the procedures that you use in taking it are important. Now, they're often spelled out in the agreement that applies to the individual, the agreement negotiated between a union and a company. But I think courts are increasingly going to pay attention to the processes that employers use in discharging or disciplining people to make sure that those processes are fair. And so that's a perspective where you may see the kinds of considerations that arbitration law has been familiar with over the years will be of relevance in civil litigation. But there'll remain differences, I think. And I think, if anything, employment law will draw on arbitration law rather than the other way around. But that's just my sense of it.
I can't add anything to that. I think the only thing I would see, I haven't done any arbitration law, and nor will I expect. So the only thing I could see is maybe working in that field with some of the types of considerations that have come out of the case in Wallace, but I certainly can't add anything to what Justice Gow just said.
Let me give you something specific that you might be able to comment on. How about the right to, or the obligation to conduct an investigation before you fire someone with serious allegations of cause, and giving the person some sort of a hearing, even at least putting to them what the reason you're firing them and giving them a chance to respond?
Do you see, that's perhaps why I mentioned Wallace. I see that as an element or a consideration in looking at the good faith or bad faith, or sometimes I wonder whether there's any such thing as neutral faith, but of the way in which a person is dismissed. So going back to Ditchburn, as though it's the only wrongful dismissal case I've ever done, but the opportunity or the failure to give Mr. Ditchburn an opportunity to explain the circumstances and to make his case before he was dismissed, I suppose subtly and without saying it, maybe then was an issue for me, an issue of concern, and post-Wallace would be something I'd be specifically able to talk about. So I think due process and a fair hearing is something that if you're advising your clients who are employers, would at least help them avoid a Wallace factor.
There was a line of cases out of Nova Scotia, in fact as high as the Court of Appeal at one time, that said if you did not give a hearing, the right to respond to the allegations before discharge, it would actually vitiate the cause, even if you had cause otherwise. Do you want to comment on that as something that might develop again in our law?
I mean, I don't, it's sort of hard to predict, even with my day job, where the law is going to go, but I'd be surprised, Howard, if we very soon saw it go that far, but there is no question. I mean, I'd like to underline what Gloria said about Wallace. I mean, you can't really read Justice Jacobucci's decision in that case without saying to yourself, he is trying to move the law gently and deliberately in the direction of greater procedural fairness at the point of discharge. And I mean, I actually think that's sound public policy, but I think it's also a clear direction that the court has sent. What that involves, I guess, is a matter for further cases to expand upon, to flesh out whether it involves an investigation in every case, whether it involves the right to respond to the assertion that's being made about cause against you before you're actually told you're terminated, whether it involves the right to any assistance if you're an individual without a union, but somebody who would like a lawyer. All those are the kinds of questions that on a case-by-case basis will be addressed. I mean, the one sort of, if I were back in the business of charging on an hourly basis for my time, I guess I would say to employers, the one kind of touchstone to use when you're dismissing somebody is, if you explained this to your kids, would they think you were being fair? Because ultimately that's what it comes down to. It comes down to whether there is a perception of fair treatment in the way in which the individual is being disciplined or discharged by the employer. I'd be surprised, though, Howard, if a complete absence of fair process ever reached the point of the court saying, well, in the face of a significant cause, we're going to find that the absence of this fairness is enough to say a dismissal without cause. I mean, I don't know. Maybe they would.
I'm going to use your reference of both of you to Wallace as a new segue into another question, which is, Wallace said, and I think it was said before that in Vorvis, that absent an independent actionable wrong, there was no longer a legal basis for punitive damages or damages for mental distress, yet courts are still awarding it. What do you think the answer is to that right now? Do you have to have an independent actionable wrong, and how broadly will that be interpreted?
Go ahead.
This is a complicated road to try to go down, and I've spent a fair bit of time thinking about it. I'm only going to go this far in saying that there's an argument to be made, in my mind, that there's no place in contract law, no place for breach of contract, which is what we're looking at strictly when in dealing with wrongful dismissal actions, for any award of punitive damages. I think there's room for an award of aggravated damages if you have the proper evidentiary support. Now, that's not what the law currently is. It's just something I've been thinking about, trying to reconcile all this different business about you can't have a punitive or damages for mental distress absent a separate tort, and trying to understand how bad faith in the dismissal and the nature of the dismissal can add to the notice period. There's parts of that quite frankly I don't fully understand, but it seems to me that if your client, and you're acting for the plaintiff, suffered some extra distress, some psychological impairment or something as a result of the way in which he or she was dismissed, and you can put before the court evidence of that, then I would suggest that maybe there's a case for aggravated damages. I don't know. You're going to disagree with me, aren't you?
No, I agree. In fact, I actually think it will be the very rare case where courts impose punitive damages. I think you're going to have a very clear showing of something well beyond the breach of contract, the dismissal without cause. I mean, that's my own instinct of the way in which the cases I see get adjudicated by my colleagues. So I think what that says is that Vorvis is taken relatively seriously, I think. As to mental distress, part of Wallace, the part of Wallace that talks about the enhancement of the notice period if there is bad treatment, if I can put it that way, on the way out the door. That's in a sort of implicit way a compensation of the individual for some kind of trauma experienced at the point of discharge. Now, it's not mental distress in the sense of a medical malpractice case and the kind of compensation that yields. But part of what the court, I think, was trying to do in Wallace was to compensate a little bit the kind of individual angst that comes from being treated unfairly, badly, when one is at the vulnerable point of discharge. So in that sense, I suppose you can say that Wallace kind of it turns a positive eye towards that way of dealing with the mental distress caused by the actual act of discharge. To go beyond that and talk about mental distress loss as a result of having wrongfully been fired is something that I think the law will not contemplate, the same way it will not contemplate punitive damages except in the rare case.
Let me add a couple of points to that. If someone's mitigated, or if they're in a fixed-term contract, then Wallace simply won't apply because extending the notice period will be irrelevant, and you can't in a fixed-term contract. And the Witten and Pilot insurance decision, which you may or may not be familiar with, awarded after Wallace punitive damages based on an insurance company violating its duty of good faith, which clearly can't be independently actionable because the court in Wallace said that gives rise to enhanced damages. It's not actionable. Does that add any perspective to how the courts might get around Wallace? Now, I'm sorry for throwing additional cases I've given you no sneak preview of, but we get it all the time in front of you two.
Yeah, I mean, for me, Howard, what the debate in the Pilot insurance case, and it's going to the Supreme Court of Canada, so I mean, I guess we'll see what they say about it. But I think it shows the difficulty of sustaining a really significant knock for punitive damages. I mean, there was a kind of reaction in our court, by a majority at least, against a very significant punitive damage award. And for me, it's reflective of the general point I was trying to make before, that is that punitive damages are a rare animal.
And I would just go back to what I said when we started this topic. I will be very interested to see what the Supreme Court of Canada does in the Pilot insurance case, and hopefully it will give us some guidance about the role, if any, that punitive damages plays when you're dealing with damages arising from a breach of contract.
Thank you. We've had a lot of discussion over the last 2 days about various statements of the Supreme Court of Canada in Hodge and Mactinger, in Wallace, in Slate, about the importance of work and the importance of termination to the emotional and psychological well-being and sense of self of each individual. Now, those are powerful words, especially since they're replicated time and time again every time the Supreme Court of Canada touches a wrongful dismissal case. But how do you think it can be used in practice, in actual cases?
When we talked about this issue the other day, Howard, I reflected on it since then, and I have to say that I think there's a difference between when a judge gets his or her hands on a wrongful dismissal case and a mortgage case. I'm not saying that mortgage cases aren't important, but you go to a pretrial, or you're case managing the case, or you're trying the case, and you know at the end of the day it's going to mean something to the people, but it's an exchange of money. And that's what it is. There may be some emotional attachment to the mortgage, I don't know. But basically, it's an exchange of money. In a wrongful, losing your job, I mean, it's not just your money that we're talking about, or the plaintiff's money, rather, or the defendant's for that matter. We're talking from the perspective of the plaintiff, in any event, about lifestyle. You're talking about social life. You're talking about the people with whom you associate on a regular basis. You're talking about future advancement opportunities. Sometimes you're talking about where they live, how far they have to go to work, whether the workplace is a safe one and a comfortable one or otherwise. You're talking about whether or not you can provide for your family. You're talking to some extent about your status in society. You're talking about self-esteem. It's a much more complicated matter to deal with than was the mortgage properly registered in terms of its impact on people's lives. So I, for one, anyway, when I'm dealing with a wrongful dismissal case at a pretrial or at the trial level or in managing the case on the way up, I try to take into consideration those additional elements that make the case that much more critical in terms of its result for the people involved. And that's not to say we spend more time on it. I'd like to spend the same amount of time on every case, the time that it needs to get to the correct result. But I think you have to think of the implications more seriously.
Yeah, my only comment on that, Howard, is very much along the same lines. I know the words are powerful words. They do carry the importance for the judiciary that Gloria enunciates. For me, they simply just reflect the reality of life. I mean, we all define ourselves in large part in terms of what we do, and that's more or less what the court was saying. So where you have a dispute over that level of important dimension of your life, it's an important dispute.
The next question relates to constructive dismissal, which used to be relatively predictable insofar as if you had a breach of some specific term of a contract of employment, it said, depending on severity, depending whether you had an obligation to mitigate, it was a constructive dismissal or wasn't. The Shaw case of the Court of Appeal seems to introduce a large element of subjectivity on the part of each trial judge. What do you think about that? Does it? And to what extent?
Well, did you talk about the Shaw case? I mean, is this sort of common currency?
It's been referred to. Do you want to do it, or should I?
One thing,
Why don't I do, I can tell you about it in 2 seconds. I'm just going to sort of summarize the head note. This is a person who's been at Xerox for a long time, and basically they end up being denied a health leave because they can't get along with their boss. Life is made miserable, and they quit. And the court says basically the employer, through all this adverse conduct that they inflicted on the individual, repudiated the entire working relationship. And while they didn't in a precise way change any term of the employee's contract, the trial judge found that in essence they'd repudiated the entire employment relationship. And I guess what Howard is saying is, well, if you can't find a precise term, can you really say that the whole relationship is repudiated by the employer? And I guess
Justice Gouge, I'm saying one more thing, just so you'll deal with that as well. First of all that, but secondly, how objective is that test? Do you expect there to be huge differences between each trial judge's view of the decency an employee is entitled to and whether or not that leads to a constructive dismissal?
Yeah, and that's a fair question. It's a question though that is part and parcel of what Gloria and I do for a living. That is standards like this standard of constructive dismissal, to put it in broad terms. When has the employer's conduct reached the point that it repudiates the employment relationship? That's a judgment call. And precisely defining the circumstances that are going to exist in every case in order to come to that conclusion is very difficult. And that's simply another way of saying the life that we live on a day-to-day basis trying to apply the law is not entirely black letter. They will depend on the facts in each case. If you say to me, is the standard in Shaw too imprecise? That is it too imprecise to serve as a guideline for employers? I'd say probably not. That is, the facts in Shaw rolled together go pretty far to say that this employer had essentially said, I'm repudiating the entire relationship. What fewer facts would reach the same result? I don't know. So I guess I say to myself, it's a standard that is precise enough to be workable, but it does say to you as an employer, constructive dismissal can occur without my having, for example, demoted somebody, if I treat them in a way that exemplifies, in essence, a negation of the employment relationship.
the point I'd like to make is, first of all, it would appear from Shaw that it is in fact an objective standard, because the court in Shaw referred to a decision of the Manitoba Court of Appeal that says that viewed objectively, the plaintiff's continued employment in the environment was no longer possible. But this takes me back to what I said at the outset about nice guys finish first. What objectively is an unfair working environment or an intolerable working environment is something that the trial judge at first instance is going to have to determine. Well, in that kind of imprecise type of scenario, the trial judge, you will want, as counsel for the plaintiff, the trial judge to find that the workplace was intolerable. As counsel for the defendant, you will want the trial judge to find that that was not so. And so part of your job is going to be to reach out to the trial judge in terms of what your client is all about. And, you know, you get a feel for the case after a day or two. And knowing that you've got this kind of imprecise test to deal with, you might just say, you know, after a while I get a feel for the situation and this is the way I want to go. And you go there. And it's going to be, I think, pretty tough to say you shouldn't have gone there if you word your judgment correctly. So it's this kind of test that is going to really require your skills as a litigator to impress upon the judge that he or she should favor your client.
You know, I acted for A&P in the Antonacci case, and just before we were called to trial, the Wallace case came out. So what do? We immediately drop any allegation of cause. But my client, the VPHR, said, you know, this Wallace just isn't fair. If we make allegations of cause and they're not sustained, we get punished with having to pay extra damages. But we're constantly being beset by plaintiffs making the most slanderous, defamatory allegations in pleadings. They often get on the public record. They get around the company. They say things they know not to be true. They exaggerate 100-fold, and there seems to be no consequence to that. Is there?
You mean, is there a separate cause of action for that?
No, is there some consequence?
Well, I suppose you could move to dismiss the lawsuit on the basis that it's frivolous and vexatious if you can establish that.
Let's
But
assume
short of
there's a
that,
basis.
I'm not sure you can do anything.
Let's assume there's a basis.
Except defend it and win.
Assume there's a basis of the cause of action, but they've made all of these other allegations that won't be proved at the end of the day. But they've still got a good 6-month case for wrongful dismissal. Will you put it at the lower end of the range? Will you award costs?
I mean, I'd guess my instinct, Howard, if I were a trial judge, and I'm not, but my instinct would be to say, if they haven't proven those allegations, I will set them aside, and I would do that on both sides.
Yeah, I just think it affects the trial judge's assessment, I keep repeating this, of your client. If you've got an irresponsible, overreaching plaintiff who's making spurious allegations that have no evidentiary foundation, the plaintiff is probably going to feel it in terms of the amount of notice without anybody saying so. I suggest it may happen. So it's like the counterclaims that are advanced by the companies that are advanced later on in the litigation just for bargaining purposes. You take up your time in these goofy counterclaims, and there's an entertainment tax that the plaintiff may enjoy as a result of the defendant taking up the court's time with a counterclaim that's instituted for negotiating purposes.
We have talked about the Felker decision of the Court of Appeal. What obligation do you think there are right now for employees to disclose that they're looking for other work?
Well, it seems to me, and this is, I guess, just my perspective on it, I think the Felker case was driven very much by the very unique facts in Felker. I think the spin on it that Kurt Macon put in the Globe and Mail is not accurate. That is, it is not a judgment that says you are exposed to dismissal if you're out looking for another job. I think there are issues of setting oneself up using confidential information in competition with your employer. But for me, the case goes nowhere close to saying if you're out looking for another job, you're exposed to, you've created cause for your dismissal.
The first reaction may be that no, you never have to tell your boss when you're out looking for opportunities to better yourself. Why would you? I think that's too quick an answer. As with everything else in this area, it's fact-driven, and if you've got a case where, take this for example, where the employer is about to hire somebody and says, look, I've been watching you in the industry for years. I'm delighted you're going to join the company. I'm going to set up a whole division just around you and the fact that you've joined the company and everybody in the industry knows you. And it's really important, this division's going to take a couple of years to build, and it's really important to me that during that period of time, you not look for other opportunities, and if you do, you let me know. Well, I think in those circumstances, it could be argued that it was a term of the employment contract, if the person accepts the position, that if that person is going out looking for work, that the employer is advised. So just to come in and say, no, you never have to tell your employer, as the appellant, if leave to appeal is granted in Felker case, may be arguing, I think is too simplistic. You have to look at the terms of the contract.
You've introduced really a detrimental reliance argument. The employer was relying on the employee in your example. Or maybe a material non-disclosure because there was active discussion about the role for the employee.
Well, or maybe an astute employer, if it's that important and you can get an employee to agree to this, has it in writing. And then it is a contractual term.
What about Kronk? Taking a oft ignored but still on the books decision of the Court of Appeal. How much room is there left for the Kronk doctrine that executives inherently are going to get more than lower status employees, all other things being equal?
I'd sort of put it the other way, Howard. It seems to me that the emphasis in Kronk is rather everybody will get the same notice regardless of their position, and that was what was corrected by the majority of our court. If you say to me over the years, is the evolution going to be to shrink the range depending on the position you're in? I think that's probably right. So I think from that perspective, the influence of the trial judgment in Kronk will have some afterlife. But I think for certainly where we're at the present time, it would be wrong to say every employee, regardless of their position in the hierarchy, can look to roughly the same notice period. I think there remains a range, and I think the range is partly informed by where the seniority and the responsibility of the position. But I do think over time that is likely to condense rather than expand even further.
Mr. Justice McPherson, the trial judge in Kronk, to some extent was successfully overruled on the lack of an evidentiary basis. So what if we came to trial developing a good evidentiary basis that in this marketplace executives are finding jobs much more quickly than more junior employees? Well, first of all, I presumably that will make a difference in that case, but will that potentially change the law?
I'm not sure there's any edict at the moment that more senior employees are going to get a longer period of notice, everything else being the same, than more junior employees. I think you have to go back to the Bardal factors. And the Bardal says that your ability to go out and find alternate employment, which to me should be one of the key factors, given we're looking at damages flowing from breach of contract, that in that kind of case, maybe the type of coming together of the ranges would take place if you were able to demonstrate that you had a senior executive who had lots of opportunity. Having said that, in that kind of scenario, the senior executive is probably going to mitigate. You won't have to deal with it.
Bardal also, of course, refers to character of employment, but character doesn't mean status. It could mean
That's
type
right.
of position.
That's right.
Or in the Brambles case, I think, at the New Brunswick Court of Appeal, they referred to perhaps it means a junior employee should get more, as one, at least one arbiter comment. What constitutes confidential information, and are there greater duties on a fiduciary to not disclose confidential information?
Well, I think what is confidential information is fact-driven. obviously the formula to Coca-Cola is confidential, but sometimes how a bolt is put on a machine or what order the bolts are put on a certain machine may be confidential as well. It really depends, and it's for whom you're acting. If you are acting for the defense, for the employer, you're going to be making the case that the order in which the bolts are put on is confidential. And if you're acting for the plaintiff, you're going to be making the case that it's not. It's like when you're doing judicial review, what's demonstrably unreasonable depends on what side you're on. Well, what's confidential depends on what side of the courtroom you're on in these types of cases. And the second part, so I don't think there's any definition, quite frankly, that would be meaningful to all cases. And as far as whether a fiduciary would always have greater responsibility, as far as I'm concerned, but whether a person on the line who knows that it's unique to the process of this company to put the bolts on in a certain order is going to be held to a different standard than a fiduciary. Do you know the answer to that?
I mean, I think the answer is the one we've both been giving, and that is it depends. I mean, the general thrust of this question seems to me to be what kind of relationship does the employee have with the employer so that the employer can say, my knowledge base is safe with this employee? And I think that's going to depend very much on the level of responsibility of the employee in the overall scheme of the company and how important the particular information is to the ongoing success of the company. It's going to be very hard, as Gloria says, to write any kind of bright line tests for that. But it will be an amalgam, I think, of, in part at least, those two things. That is, if you're dealing with a person who is at the core of the company's management team, and if you're dealing with information that is crucial to the company's continued viability, then you're going to have a set of circumstances where the company is going to be able to say, you're not able to take that information and do anything with it, and if you do, I can fire you. Where you draw the line and say beyond that, the information isn't something the company can rope in, and the individual doesn't have that kind of high duty, that'll be a fact-driven question in each case, I think.
Are you going to impose different standards on employers depending upon their size or an apparent sophistication?
Maybe I could jump in with this. It's a little bit off topic, but not really, and make reference to a case. I actually did something other than Ditchburn. A case I decided a few years ago, nobody except the parties would ever know about it, but it was McMorrin or something like that. The plaintiff, Mr. McMorrin, was in the a business agent of a union, and the union was in financial difficulty, and a trustee came in, and the trustees kept Mr. McMorrin dangling at the end of this string, saying, oh yes, we're going to call the employees back once we get our financial affairs in order, and the more senior employees are going to be called back first. And time went on, and Mr. McMorrin kept reporting in every couple of weeks to say, do you have work for me? And he was an older guy and lived and breathed the union. He was a long-term card-carrying union guy. And months went by, and the union got itself organized again and started hiring some of the junior guys and left Mr. McMorrin out in the pasture and just weren't forthright with him. Well, eventually it became clear that they were never going to bring him back in. He sued for wrongful dismissal, and he was successful. And I also added a Wallace factor in here because they just weren't honest with him for a long time, during which period he could have gone out and tried to deal with whatever options he had, but it went on so long that at the end of the day, what this gentleman did was he went back and cleaned up his skills and became a crane operator after he hadn't operated a crane in about 27 years. I'm not sure I want to be near that construction site, but I just thought what the union did was pretty bad. And the argument was advanced that because it was a union whose responsibility it is to look after the rights of employees, I should whack them harder. And I actually was tempted, but I then decided that each employer has the same obligations and has to be held to the same standard. So to the extent I came to that decision in the McMorrin case, I would probably, to be consistent, rather than necessarily right, but at least consistent, I would probably have to hold that no matter how big or small, each employer has to be held to the same standard.
You wouldn't have said this employer should have known better. It has large human resource department rather than being an owner-operator.
That argument wasn't made, but so I'm going to turn it over to Justice Gowd.
I think that, I mean, if I had to give a one-word answer to the question Howard posed, I'd say no, there isn't a different standard. Same answer Gloria gave. I mean, I guess you may say to yourself, well, what about the kind of expanded Wallace consideration that we may see down the road? And this gets pretty speculative. But if, for example, investigation becomes something that's important before you fire somebody, what if the company simply doesn't have the resources to do a significant investigation? I would have thought there's unlikely to be the same kind of penalty attached to that for a resource-deprived company as there would be for a big company. But at the end of the day, there is going to be one standard, even with the Wallace kind of factors, whether the company is big or small, and that is, did they treat the employee fairly when they booted them out the door? And so I think the answer Gloria gave in the case she did is, for me, the right answer.
I'll ask you now about wrongful resignation. First of all, its general status, and then I'm going to give you a particular question. An employee makes a representation, he intends to remain with the employer for a very long time, and then he precipitously resigns to join another employer, maybe a competitor.
It's like a law school exam, you know.
I'm trying.
I mean, I guess I say to myself, I suppose notionally there is a breach of contract if either side doesn't give reasonable notice. I don't know if there have ever been cases where a company has sued an employee for leaving without reasonable notice. I just don't know the answer to that. Once you talk about precipitously resigning to go with a competitor, it seems to me you're into issues of what kind of restraints are either explicit or implicit in the employment contract to constrain further competition, and that really, for me, is a matter of the cases of those kinds of clauses. So you'd need to say, well, is there anything that is going to be a debatable restraint of trade there? And so the answer to the question is, I need more facts.
I've got an edge on Justice Gouge on this one, only because we went separately to the same lunch last week to prepare for this. And after Justice Gouge left, having arrived at the lunch at the right time, I had an opportunity to spend some time with Howard, and we discussed this, and I thought there should be a body of law that potentially has or should develop in terms of wrongful resignation. So I went back and I checked, and yes, there is. There's not a lot of it, but there is. And even in the Ontario Court of Appeal, there's a decision in which Justice Weiler said that there are reciprocal obligations, and that while the determination of what is reasonable notice has to be regarded from the point of view of both parties, the factor to consider in how long it's going to take an employer to restructure things, the factors are different than looking at the employee. Obviously, the employer is in a position of control. The employer can go out and hire someone, whereas the employee can go out and make overtures to be hired, but might not necessarily get hired. There's also a decision of Justice Chapnick in Sure Grip, which was a 1993 decision, where she said that she thinks for the most part there would be a lesser period of notice required of departing employees than the employer who is firing someone. I found out just by happenstance today that there is an Alberta Court of Appeal decision where an employer was awarded 18 months' notice in relation to an employee who left without proper notice. The way apparently, I haven't read the decision, I just heard about it a couple of hours ago, but from a pretty reliable source, that it was a key employee, and I don't know whether there had been separate representations that gave rise to some kind of action and misrepresentation. But the court determined that the employer would have had to give the employee 18 months' notice, and that's how it fixed the employer's damages. Quite frankly, I don't understand that. I'd have to read the decision, which I hope to go back and do when I find the time. But there is law to this effect. There's not a lot of it, but I think it's an interesting potential area.
And for all of us in the room, there's a very interesting case from Alberta as well on this subject, where a lawyer sued his legal secretary, and he notionally won, but he was awarded no damages because he couldn't prove any. It's not a joke, that's a real case. And in fairness to Justice Gouge, this was not on our list of questions when you left the lunch.
No, I mean, it's an interesting question. I mean, conceptually, I guess every contract without a time limit on it can be terminated only on the giving of reasonable notice. It's sort of hard to imagine how the employer would ever demonstrate what reasonable notice it ought to have received. I mean, maybe it could say, well, yeah, you know, it's going to take me X weeks to find somebody that I can put into this position. I mean, maybe that's right. I mean, conceptually, you can sort of see how it would get structured. It's hard for me to imagine how you'd then move to a damage calculation. But I guess it could be done.
Quid in cognos, which we've talked about, talks about representations at the time of hiring, wrongful hiring, negligent misrepresentation. What about representations during the course of employment? There's been scant of any case law on that, either in a contractual context or a negligence context. Do you think there's any legal impact to that?
I don't know. I mean, the representations, I suppose, made at the time of hiring are somehow background circumstances to the making of the employment contract and gain legal importance that way. I mean, if you're talking about representations, for example, about what the employee's prospects may be, I can imagine that being a frequent kind of representation. What kind of legal effect would that have? Well, if breached, I suppose there's nothing other than, you know, it's not a contract. It's simply a representation. What can the employee do about it? I don't know. There's another question. I should have stayed at this lunch longer.
Constructive dismissal for breach of...
Yeah.
I can't help you out on that. I've never really had to consider it. I briefly leafed through the materials when I walked in the room. I saw you have a whole section on that. I think written by a friend of mine sitting at the back of the courtroom, if I remember. But the point is made in the paper, and well made, that we don't have any case law that it's built up on around that. And I think that's what keeps our job so interesting. It's the law changes. So maybe a couple years from now, there'll be some leading case about representations made in the midst of the employment relationship, and we'll all be able to talk about it. I can't talk about it now because I don't know the answer.
We were hoping you'd say something and that we could quote in front of one of your brothers or sisters.
How do you get any legal traction for it, though? I mean, it's not like a representation that's part of the reason you take the job.
Well, the person may have stayed in the employment. That may be the consideration, or the reliance in a tort context.
How can that be consideration? They're getting paid.
They may have left otherwise. There have been cases in which simply remaining in a job is considered consideration for a variety of things.
I'd forgotten how inventive lawyers can be.
Well, I know what panel to be sick for that day if I ever get there. The last question that I have before I throw it open is, and it's a series of questions really, is on issue estoppel. And there's a group of cases before your court, probably more cases in employment law before your court on that in the last couple of years than anything else. So the first one is, when is the court likely to use its discretion not to apply issue estoppel? I'm talking about, of course, in employment forms, employment standards, UIC, and then you.
Well, it's true. If over the last couple of years, there seem to have been, at least in our court, I don't know about the trial division, but certainly in our court, there has been a lot of litigation about issue estoppel in the employment context. Largely, I think, because employment law over the last 40 years has been so highly regulated. That is, there are a variety of administrative tribunals that whose existence involves regulating one aspect or another of the employment relationship, and so their decisions are now being seen in some cases to foreclose other tribunals engaging in the matter, if the other tribunal's a court, or even if the other tribunal is something less than a court, something different than a court. But our court has said in a case called Marcotte that even if all the sort of technical indicators of estoppel are there, that is, if some agency has made a decision that's final, if it's the same question and if it's the same parties, there is still a discretion in a subsequent court to carry on without issue estoppel. And if you say to me, Howard, when will that happen? Again, I think it will be in relatively rare circumstances where there is, for one reason or another, a significant unfairness to one side or the other if you didn't allow the subsequent proceeding to go forward. In the kind of cases that I think that will come up and be recognized in are cases where in the first proceeding the stakes were so totally different from the stakes in the second case. For example, in the unemployment insurance context, people apply for unemployment insurance and employers respond to claims for unemployment insurance, I suspect, without thinking very much about what their applications and their responses would look like if they were kind of poured into a wrongful dismissal case subsequently. So the forum in which the first proceeding takes place is so different, expectations, outcomes, and so on, from the forum that is the subsequent forum, the courtroom in the wrongful dismissal case, that a court is likely to say, we're not going to treat the outcome of the first proceeding to be an estoppel, preventing us from proceeding in the second case. I think, though, those cases will be relatively rare. I think they will take some significant showing of unfairness. That's my sense.
I can't add anything to that.
Okay, well, let me give you a law school question again then. Let's look at the basis of issue estoppel. It started in 1952, I think, with Carl Zeiss of the British House of Lords, and they said there's 3 tests for issue estoppel, and one of them is the earlier tribunal must be judicial, and all of the courts, all of the decisions refer to those 3 tests, and whether or not the tribunal is judicial, and decided, for example, an employment standards officer is judicial because of Dowling and Graydon. Okay, but going back to 1952, when they talked about being judicial, there was no issue estoppel in the context of administrative tribunals. So when they said judicial, they meant a court, because that's all they were talking about. So let's talk about, for example, an employment standards officer. They can conduct their own investigations without the parties being present. They can listen to quadruple hearsay. There's no procedural protection. There's no, let alone any form of a hearing. They can make findings of fact that you might find a court simply couldn't possibly make because they couldn't get at that evidence given the nature of the forma. So the question is, to what extent will the type of forum, and I mean like an employment standards officer, impact on whether or not you're going to find issue estoppel applies? The lack of procedural protections.
I'd sort of come at that in a relatively first principles way, Howard. It's always seemed to me that what issue estoppel is about is sort of saying, well, you can't have a second kick at the can. You can't kind of relitigate something, and if that's what issue estoppel is about, I recognize there are a lot of kind of technical requirements that unpack from that notion. But if its core is we let people litigate an issue once, and once they've done it to the point of finality, that's it. Finality, the need for finality in dispute resolution says you get one shot at it. Then the answer to the question, will an administrative process produce something that will result in foreclosing a subsequent court action, I think depends on how much the first process feels like a litigation of the claim, and to put it the other way, when you come to court, how much does it feel like you're doing again what you did before? You are relitigating the claim. So if you have a first process that is highly arbitrary and produces a result with a whole lot of absence of procedural fairness, it's going to be less likely that a subsequent court is going to say, this feels like we're relitigating what was done earlier. On the other hand, that's a matter of degree. But I think the fundamental question is, when the court on the second go-around is faced with the prior decision, it's going to be saying to itself, really, are we being asked to relitigate something that's already been decided upon by a dispute resolution decision maker?
I think it goes back to something that Justice Gouge said in the first part of the question, and that has to do with hardship and unfairness and injustice. I mean, that's what we're all here to try to address. So to me, in answer to the second question about the procedural deficiencies of the decision-making body that first looked at this, it would seem to me that if the court found that the procedures were so deficient that they couldn't reliably trust the result, and that it would be unjust to trust that result, then maybe there's an opening there. But I agree with Justice Gouge that it's going to be rare.
And my last point on that, taking your last point, Justice Epstein, let's assume the court finds that, but says, but you didn't have to go to court. You could have appealed within the administrative tribunal, gone from the employment standards officer to the tribunal, for example. Do you think they'd say, do you think the proper position is that you have to stay within the internal tribunal, or that we're going to disregard the decision as a nullity because we're saying denial of natural justice?
Well, I don't know if there's law on that. There may well be. I haven't had an opportunity to look at it, but I would think that once you chose a route and there was another way to have the initial decision reviewed within what your first choice was, you should probably stick to it, unless there's something egregious that went on that you can persuade a court that you should be allowed to dance at a different wedding.
I agree with that.
Questions? I'm finished mine.
Thank God.
How about some answers to the question?
Future of Sylvester. Sylvester case with limited severance by the amount of payments made for disability.
We have to repeat the questions for the purpose of the taping. What do you think the future of Sylvester is, where they said if you got disability payments paid by the employer or workers' compensation payments paid by the employer, that's deducted from damages for wrongful dismissal? You don't get both.
I mean, I don't want to answer in the specific context of Sylvester, but it seems to me courts are going to be vigilant about double recovery.
Tom?
Do you think that you have facts from Sylvester where disability was brought about by the employer's conduct, let's say an abusive case of treatment towards the employee, that would affect the positive result?
The question is, if the disability or workers' compensation recovery related to the employer's abusive conduct, in other words, the employer's abusive conduct resulted in the injury, will that change the result?
The result in a subsequent wrongful dismissal action?
It's the result of a lack of double recovery, I suspect.
Well, but in a wrongful dismissal action. That's true. That's what you're talking about. I don't know. I mean, it seems to me there, you know, that the answer I gave about Sylvester is deliberately ambiguous. I mean, you can't, whether there's double recovery or not is a question, is really the core question. And I don't know whether the cause of the disability enhances or diminishes the possibility of double recovery. I think you'd have to know more about, I'd have to know more about the facts before I could respond to that.
Other questions? Yes.
If an employee owes higher fiduciary obligations, executives, VPs, if an employer alleges just cause, is the court prepared to impose higher procedural protections into the duties of national justice, similar to what statutory employers are required to afford to employees?
Run that by me again. That is
In the normal master and servant relationship, there's no duty of fairness. When you have higher duties, for VPs, for example, they owe fiduciary obligations to the employer. Will there be a concomitant obligation on the employer in alleging just cause, if the consequences are more severe, or maybe more severe, to impose, for example, the duty to investigate prior to alleging just cause?
And for the purpose of the mic, if an employer is and if an employee is a fiduciary and just cause is alleged, are there concomitant greater obligations on the employer in, for example, its investigative role?
a lot of that. I mean, that's an interesting question. Like a lot of them, I guess my reaction is it may search for a black letter answer that probably isn't there. I'd be very surprised if a confident yes or no to that would be proven to be true either way, ultimately. I mean, my instinct is that courts will develop the law very much case by case, as opposed to the kind of bright line step that Wallace represented. I mean, Wallace is a rare case. That's why it's got so much notoriety. It represents a kind of step that I don't think happens that often. And if you say, is there likely to be a step that says those who owe a fiduciary duty are entitled to greater procedural fairness when they're dismissed? I mean, I could see the argument. I would be very surprised if there were a bright line answer given to that.
My reaction is the same, never having had to consider it, but a question like that, and it's a good one, it's a good one to think about, but against no factual backdrop is very difficult to answer. And my only gut reaction, without hearing well-developed argument on the point, is that it's difficult to imagine that people should be held to different standards. The same thing I said about the trade union, that you've got to treat people equally. And I think it would be, without knowing more about the facts behind the particular question, it would be difficult for me to come to a conclusion that somebody higher up in the organization is entitled to better treatment in the way in which he or she is fired than someone lower down in the organization.
Yes?
Yeah, I think that's a fair point. I mean, I think certainly the way you can see Wallace now, the fairness at the point of discharge is a scrutiny not so much of the position of the employee, but of the conduct of the employer. That is, it has much more to do with whether the employer accorded fairness rather than who the employee is or what the employee's circumstance was. So, I mean, I think I tend to agree with Gloria.
I'd like to thank both of you on behalf of myself, Barry Kuretzky, the Law Society, and the audience for participating today.